Hi, my name is Mark D. Copoulos, and I'm a Philadelphia criminal defense and real estate lawyer. And today I would like to talk a little bit about the Philadelphia lead disclosure law as it relates to landlords who have been sued by tenants who are currently residing in their property. The Philadelphia lead disclosure law changed in 2020-2021. Before 2020, the requirement was that any landlord who rented property constructed before 1978 that had children 6 and under in it needed to provide the tenants with a lead safe certificate. In 2020-2021, that changed, and the law now requires all landlords who have properties built before 1978 to provide tenants with a lead safe certificate at the inception of their leasehold. And what the law basically says is that if you don't provide the tenant with this lead safe certificate, the tenant can come back and sue you for all rent that was ever paid, plus during the period of noncompliance, plus attorney's fees, plus $2,000 in exemplary damages, plus any costs of inspecting the property to make it safe. Now, generally, it's important to note at the outset that PLDCL cases, as they're commonly referred to, are generally weak cases from a tenant's standpoint. And the reason why they're often weak cases that are not commonly pursued is because there's really no injury. There's no damages. And as a result of that, a lot of courts, a lot of judges, perhaps, will look at these cases with kind of a skeptical eye. You have a party who's going into court. They're suing the landlord, for example, for all the rent that they ever paid. They lived at the property during that time frame. They don't have any lead contamination. And the lawsuit basically boils down to we're suing the landlord because we didn't get our piece of paper saying that the property was lead safe. And a lot of times, by the time these cases actually get into court, the landlord has subsequently provided a Philadelphia lead safe certificate confirming that the property is completely free of lead. So one argument that you may be able to make, if not by law, by kind of equity, is that, look, Judge, there's no damages here. The tenant does not have lead contamination. We've since provided the lead safe certificate. It was a beautiful property. The tenant lived at the property. The tenant should not be entitled to a massive rental refund, a windfall, as the word that is commonly used with these cases, simply because we didn't give them a piece of paper certifying that the property was lead safe. And oftentimes there's two types of PLDCL cases. So oftentimes a landlord will file an eviction against a tenant. They'll sue for rent owed, and then the tenant will come back and file, usually through community legal services or through a public interest law center, or perhaps a lawyer who's handling the case pro bono, will file this lead claim. And really the primary purpose of the claim is just to kind of defray or abate the rent that's owed under the eviction. And if it's a case like that, where the eviction's been filed, there's this lead claim that's been filed as sort of a counterclaim, and it's, being litigated by perhaps a public interest counsel, somebody whose kind of main objective is to mitigate the tenant's damages, that may not be a major concern for a landlord. Conversely, there's some cases where the lead claim is being aggressively pursued by perhaps a major law firm that's doing public interest work, by a personal injury lawyer who's handling the case on a contingency fee basis. And those are the ones that, if you're a landlord, you need to really be concerned about and focus on, because oftentimes the attorney is not going to be compensated until and unless he gets a recovery from you. So those tend to be the cases where the litigants are much more aggressive, and the tenant is actually really going to be looking for some sort of compensation from the landlord, as opposed to kind of a reactionary lawsuit filed by a public interest attorney whose kind of main objective is to get his tenant out of the property without any kind of financial liability. In terms of defenses to lead claims, there's a lot of defenses. Oftentimes there's strong defenses. The law requires the tenant to provide reasonable access to the landlord to inspect for lead. So if the tenant is being antagonistic and isn't letting you into the property to perform the lead safe test, that may be an exception. If the law was, recently phased in for your zip code and the lease hasn't renewed yet, that may be a defense to the lead claim. And I'll try to include in the link below this video the City of Philadelphia information for when each zip code kind of phased in this new requirement for the lead safe certificate. Additionally, you may have a defense to the lead claim if the tenant has moved out of the property or subsequently been evicted. So in a lot of the statute specifically says that the Philadelphia lead disclosure law requires a lessor-lessee relationship. So if the tenant has vacated the property, they're no longer there, you could make the argument that if they file this lead claim after they've moved out, there's no lessor-lessee relationship, they really don't have standing to bring the case. Oftentimes these cases are litigated in municipal court or arbitration. The amount at issue is less than $50,000. And so the landlord often has multiple opportunities to appeal any judgment against him under this Philadelphia lead disclosure law claim and kind of tie up the tenant before any sort of recovery and really kind of make the other side work. And if you're aggressive in defending these actions, oftentimes you can win a PLDCL claim by simply hanging in there, being aggressive, forcing the tenant and their counsel to work, because oftentimes it's not worth investing substantial amounts of time and money into these PLDCL claims, because it really comes back to the bottom line here, which is that there's no substantial injury. The injury is essentially that the tenant didn't receive their lead safe certificate, which oftentimes is provided by the time the case actually gets to court. Now, if there's occupants in the property who have suffered lead contamination, or there's a child in the property who has elevated lead levels, that's a completely different story. But what we're talking about here is kind of the standard PLDCL claim of you didn't give me a lead safe certificate and therefore I'm entitled to a rental refund for all money that was ever paid. So if you've been sued under the Philadelphia lead disclosure law, don't assume that you automatically need to settle for a substantial amount of rental refund paid back to the tenant. Oftentimes you can fight and win these cases if you're aggressive and if you employ some of the defenses that I referenced in this video. If you would like to discuss any of these defenses further, or if you'd like to discuss defending your particular PLDCL claim, please don't hesitate to contact my office at 267-535-9776 for a free consultation to discuss your legal matter. Again, my name is Mark D. Copoulos. I'm a Philadelphia criminal defense and real estate lawyer, and thank you for watching my blog.